guys, Daniel Lewis Crumpton from downloadedcontent.com. If you're watching this video on YouTube, I do suggest you actually go to downloadedcontent.com, click on the CannaSense Total Wellness page, and view this video along with the previous videos in their correct order to get a better idea of what you need to know with some resources. So CannaSense is a scam. If you've heard about CannaSense and you've been looking into CannaSense, you probably have typed into a search engine, either Google or in YouTube, is CannaSense a scam? Is CannaSense illegal? Is CannaSense an illegal scam? So I wanted to address the initial objections to CannaSense, and a few other objections. I'm not really a big advocate for defending a myriad of different things, because I just think that's a waste of time for stuff that's common sense. So this isn't so much me defending CannaSense as or the legal structure CannaSense operates within, as kind of giving you guys my point of view. So let me go ahead and address the fact that I am not an attorney, so I'm not going to give you any legal advice. I'm not a member of the Bar Association, sorry. I just read the Constitution, and I work at the law of the land. I'm not a doctor. I'm not going to give you medical advice. And this is not an official CannaSense production video or anything like that. I'm an independent caregiver who is a part of the CannaSense Medical Cannabis Collective. Okay, so now that that's out of the way. So is CannaSense a scam? Well, the definition, let's go to play the word game with Merriam-Webster. The definition of scam is a fraudulent or deceptive act or operation, as in an insurance scam. So what is it that we discussed previously that CannaSense is doing? Well, CannaSense is first and foremost educating people to the benefits of cannabis as a medicine, as well as their rights under the Constitution of the United States. So they're not being fraudulent or deceptive there. They are going to help you understand what your rights are, and help you give you the resources to help you understand the benefits of cannabis as a medicine. So that is not deceptive in any type of way. If you become a member of the CannaSense Collective, you do get access to an apothecary where you can safely and lawfully obtain your medicine that is shipped discreetly to you. So they, it's like David Icke would say, it does what it says on the tin. Just takes a minute to actually go through a tour of YouTube and see several members of CannaSense actually opening up their package on video to show you that, yes, when you become a member, you do get access to the apothecary, and you do get to your medicine sent to you. So that's not deceptive in any type of a way. If we want to look at the word fraudulent, I suppose. So a fraudulent or deceptive act. Well, in Merriam-Webster dictionary, fraudulent is characterized by, based on, or done by fraud. Fraudulent use of a credit card, fraudulent claims for unemployment compensation. So it is deceitful. And once again, I think that we've actually already kind of addressed that with the fact that CannaSense does what it says. It educates you and gets you access to the medicine that you need. So the bigger question, which I intend to kind of take a lot more time up on, is this legal, or is this an illegal operation? So again, Merriam-Webster's dictionary. The definition of illegal is not according to or authorized by law. Unlawful, illicit, also not sanctioned by official rules as of a game. So I suppose what we really need to focus on is not according to or authorized by law. So we need to discuss law as Americans. We need to have an honest sit down and try to get on the same page, or pages rather, of what is the law in this country as Americans. So before I jump headlong into the rest of this video, what I would like to say is the group of people who have been objecting to CannaSense, first and foremost, the main front line of objections are coming from people who do not need cannabis as a medicine. So they really don't have any dog in the fight. They're kind of like drive-by trolls. It's a scam. It's illegal. It doesn't make any sense. This is new to me. They don't really need it, so they're not going to take a second look at anything, so they can quietly leave the room. The second group of people who have launched the most objections, either on social media or on radio shows I've been on, have been people who don't really, they're more recreational cannabis advocates and don't really need it as a medicine, so they can quietly leave the room too. For the majority of this video, I'm going to be addressing people who sincerely and genuinely have ailments that can be alleviated or eliminated through cannabis use. People who really are looking for hope to live better lives and are going to have a rational, open conversation about what this is. Now, in the second video of this series, I spoke about the trifecta that CannaSense uses, so I'm not going to really expound too much upon that because it's in the second video. And essentially, it is the three existing pieces of legislation that allow CannaSense to exist and operate. One is the Compassionate Use Act of 1996, which is California law. The second in the trifecta is the Affordable Care Act, or Obamacare, which gives us telemedicine, and of course Article 4, Section 1 of the Constitution, which is the Reciprocity Clause in the Constitution. So you can go back and kind of look at that. That is the basic framework for people who want to know how this is able to operate. So what I want to do here is, as an American who reads the Constitution, kind of go over a few principles that I can clearly see in English support CannaSense as a very not only not illegal but extremely lawful organization. So if you do have a copy of the Constitution, I would turn your attention, obviously, to Article 6 of the Constitution. And this is essentially the brick wall that most other pseudo-intellectual objections are going to hit in regards to me, anyway, and CannaSense. In Article 6 of the Constitution, paragraph 2, most of you patriots out there will recognize this as the Supremacy Clause. For those of you who don't know what the Supremacy Clause says, let's go ahead and bathe in it. This Constitution and the laws of the United States, which shall be made in pursuance thereof, and all treaties made, or which shall be made under the authority of the United States, shall be the supreme law of the land, and the judges in every state shall be bound thereby. Anything in the Constitution or laws of any state to the contrary notwithstanding. So essentially what the Supremacy Clause says is all states who are going to be a part of the United States have to ultimately bow down to the supremacy of the United States of America, and that includes judges. And of course, judges are who you're going to run into if you have an inconvenient entanglement with local law enforcement. So ultimately, the Constitution is the supreme law of the land, and it trumps every inferior piece of legislation, any act or statute. Okay? What everything below the federal government does is statutes and acts, which is given the force of law by mutual consent. So statutes and acts, state laws, things like that, ultimately have to answer to the supremacy of the Constitution. Okay, so let's go ahead and nail that in our psyche as Americans who are patriotic and who care about passing on this republic to another generation. The supreme law of the land is the Constitution, and the buck stops with the Constitution. So 99% of the objections regarding not just CannaSense or the entire operation of CannaSense, but this goes into every area of your life where your rights are being converted into privileges. So this is very important to understand that ultimately this is not a country that was set up by we the attorneys, or this is a country set up by we the people. And we've kind of been conditioned for too long to believe that we don't have the capacity to understand law, that law is some big complicated maze that you have to go to law school to understand. That's not so, okay? The people who crafted our Constitution and the people who formed this republic detested lawyers, as a matter of fact. because whenever freedom and liberty get caught up in the maze and the smoke and mirror of legalese, it's just lost. So that's why the Constitution is a very small document. So ultimately, what we as Americans really need to reinvigorate in our society is the fact that the Constitution is the supreme law of the land. So that being said, what I'd like to do now is just go through just a few Supreme Court cases that I think every patriot who has a vested interest in their rights needs to know, make a notation of. And I'm not going to be getting into an exhaustive look at these Supreme Court cases. I'm just going to be throwing them out there, and it's your responsibility to look them up for yourself and to read the cases yourself. But the first case I'd like to put your attention to is Byers versus United States, 273 U.S. 28. That's a 1927 case, and one of the findings that I want to point out to you to keep in mind is that constitutional provisions for the security of person and property are to be liberally construed, and, quote, it is the duty of courts to be watchful for the constitutional rights of the citizen and against any stealthy encroachments thereon, end quote. So basically, any constitutional provision intended to confer a benefit should be liberally construed in favor of the clearly intended and expressly designated beneficiary. That's you and that's me. So to kind of put my own interpretation on it, when you are trying to when you're looking at the Constitution and the Bill of Rights, if you as an American citizen can pull a right out of the Bill of Rights, then the courts have to liberally construe that right in your favor, the beneficiary of the United States Constitution. That's you and me. So I'd like you to keep that in mind when you are you're pursuing this type of study, and whenever you are using your rights as an American. If you can pull a right out of the Bill of Rights, the courts have to liberally construe it in your favor. So before I move on to any other Supreme Court rulings or cases, what I would like to do is take your attention to the Bill of Rights and the Constitution, to the Ninth Amendment. And the Ninth Amendment reads, the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. So you guys are pretty intelligent. You don't need a law degree to understand that what this is saying is that though the founding fathers listed certain rights in the Constitution, that is not to be confused or interpreted to mean those are the only rights that an American has. You have many rights, many rights. As I said, if you can pull a right from the Bill of Rights underneath, life, liberty, the pursuit of happiness, then you have that right too. So let's go straight to the 10th Amendment, which says, the powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively or to the people. And in patriot circles, you hear the expressions state sovereignty and personal sovereignty, or state nullification and personal nullification. And so that's really what I like to focus on is personal nullification, because you're going to be very hard pressed to find any state governor that's willing to use state nullification. It's out there, but it's kind of rare. So ultimately, in the age that we happen to be living in, lack of education on the Bill of Rights and the Constitution really puts maintaining the republic in the area of the people, and the people nullifying unconstitutional statutes, acts, and laws personally, which is kind of the avenue in which I operate. So I want to just go ahead and reiterate. The Ninth Amendment basically says that the list of in the Constitution of certain rights is not to be construed or confused to mean those are the only rights that you have. So in context of seeking cannabis as a medicine and all of that, this is going to fall under the Ninth Amendment. If you can show me somewhere in the Constitution where the founding fathers explicitly restricted the use of an herb, a plant, for your own well-being, which is underneath the interpretation of the pursuit of happiness, then you might have some type of a logical leg to stand on. However, I can't find it anywhere. So just want you to be aware of the 9th and the 10th Amendment there. So let's move on to the next Supreme Court cases that you need to know. So moving on to 3 very important Supreme Court cases that have not been overturned, and I think are extremely important for any patriot to know. And like I said previously, please look these cases up and read them for yourself. I'm just going to be summating these cases. So the first one is Marbury versus Madison, 5 U.S. 137. That's an 1803 case. Essentially, what Marbury versus Madison has done is something absolutely brilliant, which is kind of support personal nullification of any inferior law underneath the Constitution. So Marbury versus Madison, in summation, quote, "No provision of the Constitution is designed to be without effect. Anything that is in conflict is null and void of law. Clearly, for a secondary law to come in conflict with the supreme law was illogical, for certainly the supreme law would prevail over all other laws, and certainly our forefathers had intended that the supreme law would be the basis of all law, and for any law to come in conflict would be null and void of law. It would bear no power to enforce, it would bear no obligation to obey, it would purport to settle as if it had never existed, for unconstitutionality would date from the enactment of such a law, not from the date so branded in open court of law. No courts are bound to uphold it, and no citizens are bound to obey it. It operates as a near nullity or a fiction of law," end quote. So, essentially, per Marbury versus Madison, if any state within any law which is passed is unconstitutional, the whole law is unconstitutional. You can't have the states coming along and writing a law that contradicts the supreme law. The supreme law of the land is going to win out any time. So the reason Marbury versus Madison is important is because it basically reaffirms the Supremacy Clause, and in conjunction with the 9th Amendment, basically says if you could pull it right out of the Constitution, and the state comes along and writes some piece of legislation that says it's illegal, then if it violates your right to engage in that right, you don't have to obey it, and no state can enforce it really, because it's a nullity or a fiction of law. And what I also find important about Marbury versus Madison is that it does not have to be branded unconstitutional in open court of law. It is unconstitutional before the ink is dry. So whenever you're dealing with conversations where people are very adamant about getting certain laws reversed or overturned and all that good stuff, the first question that you should ask to save yourself a lot of time and energy is, does it contradict the Constitution? If it does, it's already a fiction of law. You don't have to brand it that way in open court of law. So that's Marbury versus Madison, 5 U.S. 137, and that's an 1803 case. Please familiarize yourself with that one. And the next Supreme Court case we need to look at is Murdock versus Pennsylvania, 319 U.S. 105. This is a 1943 case. And I'm going to just quote a little bit from it. It says, quote, "A state may not impose a charge for the enjoyment of a right granted by the federal Constitution, and that a fiat license tax here involves restraints and advance the constitutional liberties of press and religion, and inevitably tends to suppress their existence. That the ordinance is non-discriminatory and that it applies also to peddlers of wares and merchandise is immaterial. The liberties granted by the First Amendment are and in a preferred position, since the privilege in question is guaranteed by the federal Constitution and exists independently of the state's authority. The inquiry as to whether the state has given something for which it cannot ask a return is irrelevant. No state may convert any secured liberty into a privilege and issue a license and a fee for it." Now, even though I don't really want to focus on cannabis use as a First Amendment thing, which it very much is, especially in every faith that I'm aware of, and every scripture I'm aware of, and including my own faith. The use of cannabis is a First Amendment issue. That should be noted. I don't want to dwell on it, but Murdock versus Pennsylvania is in your corner if you take that route. What I really want to focus on with Murdock versus Pennsylvania is that no state may convert any secured liberty into a privilege, and a privilege can be taken away from you. So I really want to point that out with Murdock versus Pennsylvania. And now, of course, states have come along after that Supreme Court case and have ignorantly tried to convert rights into privileges and issue license and fees for them, such as hunting license, driving license, marriage license, things that you already have a right to do under the Constitution. They have tried to issue a license and a fee for it. So that brings us to the next Supreme Court case, which is Shuttlesworth versus Alabama, 373. I said Alabama. 373 U.S. 262. This is a 1962 case, and basically, that case says, quote, if the state does convert your right into a privilege and issue a license and a fee for it, you can ignore the license and fee and engage the right with impunity, which means you cannot be punished. So that is Shuttlesworth versus Birmingham, Alabama, 373 U.S. 262. Please look that case up along with the others. So moving on just slightly, what I would like to kind of point out to you is that whenever you are moved against by the state, the standards for a criminal violation have to have what's called willful intent. So from United States versus Bishop 412 U.S. 346, which is a 1973 case, one, it must be proven that you are the party. Two, it must be proven that you had the method or opportunity to do the thing. And three, what I really want you to focus on is it must be proven that you did this with willful intent, or whatever it is that they're accusing you of, any crime that they're accusing you of. It must be proven that you did it with a willful intent. And of course, the word willfulness means an evil motive or intent to avoid a known duty or task under a law with a moral certainty. So essentially, if you can pull a right from the Bill of Rights and you're standing on your rights, and the states come along and try to contradict the supreme law of the land with licenses, fees, or statutes or acts, and you engage in your right with impunity, standing on the supreme law of the land, no state can move against you or prove willful intent or an evil motive or intent to avoid a known duty or task under a law with a moral certainty. If you're standing on your rights, then you can't have willful intent of doing some nefarious thing against a known law or something. You're simply standing on your rights. So proving willful intent is going to be quite difficult if you are standing, living, walking, and operating under the Bill of Rights, which is the supreme law of the land. That's United States versus Bishop 412 U.S. 346. That's a 1973 case. Now, of course, in a perfect world, in a perfect republic, we would have everyone who wears a badge or anyone who takes an oath to the Constitution very aware of these types of things, but you and I both know we do not live in that world. We have a lot of people who are in, quote, law enforcement or who take the position of peace officers that do not know the law. They do not know the Constitution. They kind of fall into the category of, I'm just doing my job. And so, even when you are in the right and you are exercising your rights, there are going to be occasions where somebody with a cage and a badge and a gun or a gavel will try to violate your rights, and we will deal with that probably in the next video. But before we kind of wrap this particular part up, I would reference Yickwo versus Hopkins, 118 U.S. 356, which is an 1886 case that I urge you to actually look up. What I want you to take note of is that it was determined by Justice Matthews in Yickwo versus Hopkins that it was acceptable to hold administrators of the law liable when they abused their authority. So, just like we're often told ignorance is no excuse, whenever anybody with a badge or a gun or a cage or a gavel or who is in any type of, quote, authority over you, when they violate your rights that you are standing on, they are liable. And so that's something to keep in mind. That's Yickwo versus Hopkins, 118 U.S. 356, 1886. So before this video gets too awful long, I want to go ahead and cap it off with answering the initial question, which is CannaSense an illegal scam? Well, we've already looked at if it's a scam or not. They say they're going to educate people as to their rights and the benefits of medicinal cannabis, and they do. They say that they're going to get you access to an apothecary with clean and lawful medicine, and they do that as well. So the elephant in the proverbial room of this video is it illegal? Well, I think after 20 minutes or so of going through the Bill of Rights, the Constitution, and several Supreme Court cases that show unequivocally that, one, if you could pull a right from the Bill of Rights and stand on it, there's no willful intent on your part to break the law. And any inferior legislature, states, or otherwise cannot come along and write a law that contradicts the Constitution, which is to secure your right to life, liberty, and the pursuit of happiness. The rest is a lot of details. But the thing that I really want to leave you with is that we as Americans need to get back to the basics of what this country is about. I know that it's very fun and entertaining to listen to hours ad nauseum of, quote, alternative media or patriot media or truth media where they really dissect, every law that comes across the board every single day, and it keeps a news feed going. But in all actuality, most of these issues have been resolved by our founding fathers for over a century or two, okay? And it's very, very simple. You can't write unconstitutional laws. You can't write any piece of legislation that contradicts your right for life, liberty, and the pursuit of happiness. And, of course, happiness includes your well-being. Pursuing cannabis as a medicine is one of the very embodiments of why we are Americans. So I think in this video, I've kind of illustrated that and of course, the scope of this video is more than just cannabis use if you really know how to apply what I've been talking about here. But it certainly applies to CannaSense, and it certainly applies to medicinal cannabis and cannabis usage. That if you could pull the right from the Bill of Rights and you're standing on your rights, you have no willful intent to violate any type of statute or act. So, yeah, it's legal. What I find even more profound about CannaSense is that they go a step above and beyond that, and they actually have, with the Trifecta, have built a bridge of compromise to meet the state or states halfway by doing what I call swinging in the ghettos of legalese. By using the Trifecta, which is state law, and the Affordable Health Care, the California law, compassionate use, the Affordable Care Act. That's kind of a nice segue to the state to meet them halfway, to show that those who are becoming compliant members of CannaSense are going above and beyond to pursue cannabis as a medicine as lawfully as we can. So if you want my opinion and my perspective as an American that reads the Constitution and lives at the law of the land, CannaSense is not a scam, and it is not an illegal operation. It is very American and very constitutional. So I hope that answers the question. And of course, in the next video, I will be dealing with some more of the more minute objections to CannaSense that I believe the Supremacy Clause really answers anyway, but some people need those dots connected for them. So I hope you check out the next video where I will continue this discussion regarding the objections of CannaSense. Until then, be well.